All right, hey everyone. Everyone's gonna turn the volume down. Everyone's good. Okay. Hey, all right. So we are live, just so you know, live streaming this. So thank you everyone for attending today. This is our first of 3 work group sessions. Can everyone hear me, by the way? Okay, great. And this is essentially, the Mac Middleton style work session where we have just a committee product, committee members participate. We have a dialogue on an issue, work things out, and we have folks that are in our gallery, so to speak, that we can appeal to, ask them questions. They're experts, but they won't otherwise participate unless we directly engage. This is a little bit different because it's over Zoom and this platform. So we've got a number of folks. You'll see the 28 participants that are in the gallery, just like they'd be in the committee room watching during this work session. And so that's generally the format. This is going to be, by default, the most transparent process because of everything's going to be live streamed and memorialized. So just so the members know, because we have more than 6 members here, we're subject to the Open Meetings Act. We have to live stream under these conditions. And so just so the members are all aware of that. You will also, if you look under the participants, you'll be able to see who is in the gallery, panelists, and then you have attendees. So you'll be able to see both of those things. You can see everyone that's here. So obviously we've gone through, this has been an iterative process. We've gone through several chops. We had hearings in the fall and summer, and we had hearings, this year during session. And we're gonna have 3 work sessions on items of the police reform package that have been the most difficult, the most complex, and have just through our course of conversation engendered the most conversation and pushback and deliberation. So the schedule you should have received, just an agenda today, is we have one subject, which is the Maryland Public Information Act, just access to personnel records, investigations of law enforcement officers. The basis of today's discussion is going to be Senate Bill 178, which is Senator Carter's bill. We'll just use that as the baseline for discussion. This is going to last no longer than 2 hours. We have a hard stop at 4 if we're not complete before, if we haven't finished up before then. So I know it's been a long week and I want to keep everyone here. Next Friday, we are going to do use of force, whistleblower protection, and duty to intervene. And then that following Monday, we're just going to dedicate entirely to the Law Enforcement Officers Bill of Rights, that discussion. And so the other portions of the police reform package will be discussed when we do our normal voting sessions and we do our normal workshop sessions for any other piece of legislation. So with that, I'm actually going to, just almost like we do in a voting session, I'm going to kick it over to council to just outline where we're going to start today with Senate Bill 178, exactly like we do in a voting session. It's going to read kind of a synopsis of the bill, and then we are going to dive in. And Senator Carter, please feel free to just chime in, or I'm going to open up the floor as soon as Jamie finishes to you, and then we'll get our discussion started. So with that, I'll mute myself, and council, if you want to take it away.
So Senate Bill 178 establishes that a record relating to an administrative or criminal investigation of misconduct by a law enforcement officer, including an internal affairs investigatory record, a hearing record, and records relating to disciplinary decisions, are not a personnel record for the purpose of the MPIA. Therefore, these records are not subject to mandatory denial of inspection under the PIA. Instead, they are subject to discretionary denial, and a custodian may deny inspection by a person in interest only under specified conditions that under current law apply to denial of various investigatory records. The bill is required to be construed prospectively to any PIA request made on or after the bill's October 1st, 2021 effective date.
All right, so the format here is a little different because I can't unmute myself. Only the council here can do it. So you're gonna have to raise your hand either through the icon or on the screen so we can see who's been calling you. Senator Castley has his hand raised, but I want Senator Carter to go first real quick. If you had something to say, Senator Carter, we'll open up for you and then go right to Senator Castley.
Thank you for this work group, Chairman Smith. I think it's a good opportunity for us to flesh out the issues. I think that the bill is self-explanatory, and so I'd rather hear the questions and concerns and work them out as we go along. Thank you.
Senator Castley.
Okay, I'm unmuted now. Thank you. I echo Senator Carter's laudatory remarks regarding this format. So thank you for doing this. I just preliminarily want to point out that the Senate, just like less than an hour ago, approved a request to hide the home address of notary publics. And now we want to open up all the personnel files of police officers. There's a really big incongruity there, because I've never heard of anybody asking for anything about a notary public other than lawyers trying to find the right person to subpoena to disclose their records. So that aside, I thought that the first year this came up, I totally rejected it. Then I looked at the chief's and sheriff's proposal this year. I think that is a really excellent compromise. My concern, as I mentioned last night in discussing my bill, my concern with all this is I don't want to set up an environment that good people don't want to be cops. We've got to be careful moving forward that we're establishing an atmosphere. We can't just focus on today's problems. That's my point. I can't just focus on that we got to discipline bad cops that might exist today in different departments. The bigger issue, we got to, don't get lost in the weeds here. We got to elevate ourselves at the macro level here and recognize that the end game here is to bring good people into policing of all walks of life. Get good people in policing, give them good training, and keep them in the force. If we can do that, I think we end up. That's where we really got to be here when we look at all this stuff. So when we're looking at bills like this, I think it's important that we as political leaders don't just focus on the micro task, which is get rid of bad cops. That's a micro task. The majority of cops are good, and we've got to be careful that in our effort to zero in on a bad cop, that we don't end up setting up an atmosphere that's unfavorable to people who are still in high school or college, who are looking to be cops, people who are currently young cops, because we've got to have an atmosphere that says, I have a right to privacy in my personal life, that recognizes that the best of us are going to screw up in our lives, that when you're a cop and you screw up in your personal life, probably the chief is going to go look at it, that we all have screw ups in various aspects of our lives. It's inevitable. If you're going to be a cop for 30 years, yes, you are going to screw up in some fashion, and there's a pretty good chance that somebody from internal investigation is going to look to say what happened in your marriage, what happened in your family picnic, what happened in your part-time job. And so we just got to be careful that we don't set up an atmosphere that says you're not wanted. The good people are not wanted. This policing is only open to people who can't get a job anyplace else. And I'm with the kind of cops who are in policing because they want to be, not because they're stuck because they can get a different job. Thank you.
Appreciate that. Thank you, Senator Castley. Senator Carter needs to be unmuted.
Thank you again, Mr. Chair. My response to Senator Castley is that I just believe that we have a completely different perspective on what the ramifications of this legislation will do. I actually see this as an opportunity for the good cops that we know exist and hear so much about. They aren't in any danger. In fact, it's a chance to show that the overwhelming majority of police officers have integrity. it's also an opportunity, to the extent that any of these records might ever be disclosed, for the ones that are not sustained to actually be showcased as well. That, you know, they weren't warranted, you know, on those chances that some of them might be disclosed under this act. I think that we have to really take seriously the fact that we have case after case, constituent after constituent all across the state, it's been determined, that have been victims of not only abuse, brutality by some law enforcement officers, but that the agency themselves that would not disclose the investigatory file or whether there was even any discipline rendered, that has been a roadblock to people feeling that they can trust the police agencies to adequately investigate and implement discipline. It's also really important to consider the fact that there are multiple other states that disclose the records, and we haven't heard of any tragedies regarding officers. I also believe that Senator Cassidy overstates what is disclosable, because this is not about disclosing the personal lives of officers. This is specifically about disciplinary allegations and their investigation and their outcomes. It is not about the personal lives of officers. It is primarily about the conduct, their public conduct in their public service jobs, and which, you know, lends itself to the fact that their disciplinary records should not be private. That's my response.
So Senator West and then Senator Cassidy.
Thanks, Mr. Chair. So here is one of the concerns I have about this. I'm envisioning a criminal case in which someone's being prosecuted, and the public defender finds out a week before the trial that Officer Abel is the officer who apprehended the defendant, and the public defender goes into the files and gets all the information about Officer Abel, and then at the trial puts Officer Abel on the stand, or if Officer Abel's already on the stand during cross-examination, says, Officer Abel, isn't it a fact that you were the subject of the following complaint in 2012? And when Officer Abel then tries to defend himself, Officer, I just asked you a yes or no question. Were you the subject of a complaint in 2012? And then will follow a recitation of any complaint filed against Officer Abel between 2012 and 2021 in this case, as an attempt to try to impeach his credibility and disparage his reputation in front of the jury. Senator Carter, you are a public defender. Isn't that what you would do and what any good public defender would do? Get all the information possible about an officer, including all the information in the personnel records, so you could attack the officer on the stand.
So first of all, I thank you for giving me the honor of calling me a public defender. I was actually a public defender like 1,000 years ago for about 2
Okay. Well, once one, always one.
But so there's a couple of things with that. One, the legislation itself would give the discretion and specifically addresses the ability to not for there to be the custodian of records to not disclose information if it could impact ongoing litigation or an ongoing criminal case or investigation. So
interfere with how asking questions on cross-examination about the officer's disciplinary record, how would that interfere with the law enforcement proceeding?
Well, you know, there is an argument that it could cause bias, but I also think that there are checks and balances, because to the extent that an officer decides to take the stand, which that's a big if, because an officer doesn't take the stand, there's no opportunity to impeach his testimony or his credibility, his or her testimony or credibility. But certainly you're also aware that if that were to happen in a criminal case, then there's something called opening the door. And so the officer or the other side would be well within their rights to offer a full explanation, which actually could vote in the officer's favor. Because if one side attempts to just give a minimal amount of information to make a point, the other side then has an opportunity to expand upon it. So I don't actually see that as a legitimate reason not to move forward with the legislation. But
Senator West.
some words that you're suggesting that would tighten up that area, I mean, I'm open to hear it, but if it's just like you generally don't want the legislation, then I get that too.
Senator West, to also, if I may, Senator Carter, I'm trying to find the rules of evidence here, but I do see that at this point, since we've got him here, let's do this. I see Mr. Roca may be able to shed light. If you've got something that's directly responsive to this, I'm going to ask you. Don't worry. I see Huff and I see Cassie. We're going to ask the law enforcement folks as well, so don't worry. It's going to be a balanced discussion. But I see if you're there, I'm going to ask you to respond.
Thank you, Mr. Chairman. With respect to the concern that Senator West just raised, I think it's important to understand that it really doesn't have anything to do with this bill. So whether or not so-called prior bad acts come in a trial, prior bad acts by a witness, is controlled not by the MPIA and has nothing to do with the MPIA. It's an evidentiary question. It's up to the judge as to whether such prior bad acts are admissible. They're almost never admissible. They're admissible. The most common scenario in which they're admissible is when the prior bad acts would impeach the credibility of the witness. And if they're going to come in, the existence or non-existence of a complaint is not what comes in. I mean, the prior bad act, if it's going to come in as evidence, there has to be sufficient proof of the prior bad act for it to come in. And the existence or non-existence of a complaint has nothing to do with proof of the prior bad act. If there was a prior bad act that bears on the credibility of the witness, then it should come in and a judge will let it in. But none of that has anything to do with the MPIA. And so this is really a shibboleth that has nothing to do with the bill before us.
It's unfortunate we don't have a state's attorney here this afternoon. I'd like to hear, if possible, on this issue from the state's attorney, but in the absence of one, all we have is the ACLU.
Okay, that's false. But so I'm going to ask we're going to have a balanced discussion. So I am going to, looking in the room here, and I see Andrea Mansfield, and who's the individual that can take legal questions? Russ Hamill. Is Russ Hamill here?
Could we maybe take down the bill? I have a copy of the bill, but I can't see the various faces. If my statement that we just have the ACLU is false, it's because I couldn't see who's in the room.
Okay, let's do that then. Sandy, you can take down the bill. And then let's see, Russ Hamill. If you are able to answer that, if you want to get in and answer that question or add your perspective, it would be appreciated. We can unmute you if you'd like. Okay, you're unmuted.
Can you hear me, sir?
We can, yes.
Okay. I really don't have much to offer on that except the perspective that it isn't lost on me that my esteemed colleague there is referring to prior bad acts and referring to a witness, a police officer witness testifying, when in my recollection that is the evidentiary terminology used to refer to a defendant on the stand and whether their prior bad acts would be present evidentiary value as towards guilt or innocence in a criminal trial. So it just causes me concern that that's how we're going to refer to a witness in a case there. What the concern here is, as I believe Senator West offered, that the trial gets mired down into, does an officer have prior mere allegations in reference to nearly anything? We could get bogged down into allegations of speeding, allegations into uniforms not being appropriate, just many different allegations that officers are subject to discipline on. Believe it or not, we discipline officers for name tags not being on, and speeding and other cases. When the trial could be completely derailed into that area, whereas if you are a defendant in a criminal case, it is rare that prior bad acts can even be brought in testimony in regards to your guilt or innocence. And I believe, as offered earlier, and I'm sorry, I don't even recall now who offered it, that there's good compromise beyond here. We're about transparency as well. We want fair trials, we want fair processes, but fairness doesn't stop at the gate of when an officer would be testifying. Fairness goes across the board. And the idea in these trials is to get to truth. And in order, because these aren't games. There's a lot at stake in criminal trials. And we agree with that. I think everybody in this room, from everything I've heard through the summer and to today, everybody is deeply concerned with that. But I believe there's good compromises that have been offered, that have been referred to earlier, that can help this matter. And I went on a little long there, and I appreciate you not cutting me off, Chairman, Senator Smith. Thank you.
I appreciate it. Thanks. Good perspective. All right, Senator Castley and then Senator Huff.
Thanks. I just wanted to respond to Senator Carter. She said that comparing this to all other states, the challenge we have in anytime we start doing these comparisons with other states is there's a lot of other laws and regulations involved. So if we're going to compare with another state, we're going to say, oh, this is different than other states. It's really necessary for you to bring and say, here is that state's standard, here's how it works, and lay it out. Because every time I'm in the committee and see people say, well, we're the only state that does that, look at this. And then I take the hours to go and pull out the other states and I say, well, wait a second, we're comparing apples to zebras. This isn't even a close comparison here. That you're taking a little piece of what Maryland has and a little piece of what other state has and say, oh, we're not like that. Yeah, but if you got to take all the stuff. So that's my first one. Then as far as this is not about their personal lives. Well, unlike the guy that works for General Motors or for a law office somewhere, police officers' misconduct can relate to, and Frank Boston's on here, so we can probably hear from him a little bit better. But some of the stuff I think you'll find in there are that investigations because he was in a bar scuffle or an alleged bar scuffle, an alleged domestic dispute, an alleged dispute with his neighbor, a minor traffic offense. A negative interaction with a co-employee at a weekend get together, 2 or 3 cops get together, just having a nice evening and something goes wrong. Alleged insubordination where the cops not exactly getting along with their superior. The allegations that a cop is gambling or that they're habitually late or they were late a period of times when they were trying to help their wife who's suffering from cancer or something and people didn't know that. So we're gonna get into that. Bad driving on his weekend trip to Des Moines or something like that. All these are all things that you would never see for non-cops. I mean, if you went into my personnel file, if I worked anywhere but for a police department, all you're gonna see is what I did as an employee during my work hours. You're not gonna see stuff about all these things we're talking about. So it is very revealing. And it is to have that stuff, everything that you do. And these are young people. Cops are, a lot of these guys are in their 20s and gals, excuse me, I don't mean to be sexist. A lot of these guys and gals are really active people. They're fit, they're trim, they're go-getter people. They have active social lives, active recreation lives. They're not hermits. It's the kind of people we want in as police, I believe, by the way, people who are not, sort of stuck in their own little heads. They mess up, like we all mess up every day in our personal lives, but our families forgive us, our neighbors forgive us, and it doesn't become a matter of public record. So it just troubles me that this committee, who is so up on denying access to violent juvenile offenders, information, anybody about a violent juvenile offender, don't tell the public. Anything about a notary, don't tell the public. But suddenly it's a cop, make them strip naked and parade down Main Street every day. I just don't get this attitude. The police have proposed a very reasonable a compromise on matters that ought to be revealed from a personnel files, and just sort of dogged determination to say, hey, cops cannot have a personal life. We can't go there. If that's the position, then we're going to be wasting our time. I think if we want to pull out different things, we start with, I would suggest we start with what the police are requesting and start, can we agree to this? Pull out each sentence and say, is this something that's good? Do we need to pull something else in? Does that, maybe the police suggestions are a little bit too narrow. Okay, open for discussion. Maybe a little bit too broad, open for discussion. But absolutely reject their proposals, I think are inappropriate. So thank you, Mr. Chairman.
Thank you, Senator Cassidy. Senator Huff, you're next.
All right, thank you very much. And I apologize, I'm gonna be jumping on. Am I off? Okay.
You're on, yeah, you're on.
Okay. So I apologize, I'm gonna be jumping on and off. I have a couple meetings. I got the Secretary of Health waiting for me right now, but I agree in principle with Senator Cassidy's saying about the original proposal being overly broad. It reminds me of the argument we have on case search, where deciding what should be up there on case search and what shouldn't be. It seems like this bill as it comes in basically puts, any of these administrative things that were just mentioned would be put up in public. So I guess I agree the chief's proposal is much better, but I have a question that maybe if Frank Boston or the FOP, one of them can answer, because on the chief proposal, it talks about complaints that were sustained. And I always was told by someone that our definition of sustained is different than what we're thinking, that just because a complaint is sustained, they still go through their appeal board, they still, and sometimes this can be overturned. So a sustained isn't necessarily, as we think of it, as like almost a conviction. We're using it as a term like a conviction. So maybe Frank, could you explain that to me, that what does the term sustained actually mean?
All right, so yeah, Mr. Boston, go ahead. I'm going to unmute you here. There you go.
Yeah. Good afternoon, Mr. Chair and members of the committee. I'm Frank Boston here on behalf of the FOP. I first want to say, Senator Cassidy, you were right on. I agree. You mentioned me, but I couldn't have said it better than what you said. So thank you. But yeah, you're right. The term sustained, Senator Huff, seems to be confusing. And we're thinking guilty and not guilty. Sustained just means there's enough to go forward. It doesn't mean that there's been a guilty finding or anything like that. That's what sustained means.
Yeah, so like my counter, so this would mean, not to pick on the chiefs or sheriffs who are here who wanted this, but they would mean the chief may have decided it was sustained to go forward, but then they go through the process and it ends up, they're not being disciplined. Actually, there's more to the story. So I can understand why the chiefs would want that in there, but for y'all, or for the rank and file officer, what would be, I guess, a better term than sustained? What's the end process finding? What would be, is there a better term for that?
You're speaking to me, or you were speaking to me?
Yeah.
Oh, I'm sorry. I thought you were.
Yeah, sorry, I'm speaking to you, Frank.
Yeah. I mean, it's a term that, we've used, we're accustomed to, but, and again, I had to check with the clients. I mean, we're open to a change in the use of terminology as long as it's consistent and fully understood. But I think you're right. Part of the confusion is sustained and unsustained is different from guilty and not guilty. And so, terminology needs to be cleared up.
Yeah, because my understanding, the best way is that sustained almost means like you were charged. They found evidence to charge you, but the whole story hasn't been told yet because you have a process that you go through. And just as we do a due process system where you're ultimately found guilty or not.
That is correct.
For Senator Huff, I'm going to pull in Chief Morris here because you did kind of mention the chiefs and sheriff's perspective.
Yeah, sure.
So Chief Morris. And then Mr. Roca, your hand is still up. if you could put it down and then put it back up if you want it up again. But I just want to make sure, we don't miss you, but we'll if someone calls on you, we'll let you know. But there you go. Thank you. All right. Chief Morris, you're on.
Hi, good afternoon, Mr. Chairman. Thank you for recognizing me. And Senator Huff, it's a great question, and it's one that should be clarified. The chiefs and sheriffs looked at the sustained as amounting to probable cause, equating it to a criminal case. And I want to be clear, we're not suggesting that an administrative investigation is any way, shape, or form equivalent to a criminal case. But in a criminal case, once probable cause is established, those records are posted on, I believe you said, on Maryland Case Search, even with the probable cause. And what we looked at were sustained complaints specifically related to allegations of sexual assault, dishonesty, perjury, false statement, discriminatory practices, those most egregious types of cases. And in those cases, the chiefs and sheriffs felt that if the investigation supported the sustained complaint in those specific instances, that it's of public concern, and we offered it as a concession. The other cases of sustained or more importantly, non-sustained complaints that Senator Castley mentioned earlier, we feel need to continue to be protected so that there's not this wholesale release of an individual's entire life as, again, parading down Main Street. Does that explain our position sufficiently? I want to make sure I'm clear. Thank you.
Thumbs up from Senator Huff. Okay, well, I wanted to kind of guide the discussion a little bit more and direct it toward, the bill before us. Everyone's got the piece of legislation so we can work off it, like you said, Senator West. So I think we're just pivoting off of the conversation. If you go to page 3 of the bill, talks about, this does just a disciplinary decision. So this bill subjects the entire package, of that personnel record is now no longer a personnel record, and therefore, subject to disclosure. I did, Senator Carter, if it's okay with you, I wanted to talk about just from lines 14, to 27 on page 3, because especially the 7 criteria that are were lifted from another section here for PIA. I do want to kind of talk a little bit about it, because I think we all now understand the distinction between sustained, not sustained, and what this bill is proposing. That the whole package is all there for the disciplinary decision. But that I do want to talk about just the process of disclosure and the criteria, and that I've always just been focused on like the permissiveness, that it's not the misnomer on the bill is that it's an automatic kind of disclosure. And so I just wanted this speaks to the process, and that it's just not automatic. So Senator Carter, if you want to just, we can walk through it, or I want to bring in David Roca, but then also I want to bring in FOP and chiefs and sheriffs to get their perspective on what this process looks like. And just, tell us what are the problems, what are the benefits, just give your analysis and your feedback on that, because I feel like I didn't get enough of that during the hearing. So Senator Carter, I can leave it to you, or I can just go through I can just hit the 3 that are here, the chief sheriffs, FOP, and ACLU. But
That's fine. I'd like to hear what they have to say.
Okay. So we'll just do the round robin like we just did. We can start off with Mr. Roca, then we'll go to either Mr. Hamill, and then we'll go to FOP. I see a couple folks from FOP here that can offer their perspective, and Chief Morris, and if you have someone else, I see Sheriff Popkins here, if Sheriff Popkins cares to comment. So we'll start off with you, Mr. Roca.
Thank you, Mr. Chairman. Can I very briefly address the evidentiary question that was discussed earlier?
Sure.
I believe Senator West said he didn't want to take my word for it. I would point out that Scott Schellenberger, when this was discussed at the hearing, agreed that my description of how things worked was correct. And Chief Hamill, I think, suggested that I was talking only about admission of prior bad acts with respect to defendants. And I would point the committee to Maryland Rule 5-608B, which is impeachment by examination regarding witnesses' own prior conduct not resulting in convictions. And I'll quote the rule because it's pretty short. The court may permit any witness to be examined regarding the witness's own prior conduct that did not result in a conviction, but that the court finds probative of a character trait of untruthfulness. Upon objection, however, the court may permit the inquiry only if the questioner, outside the hearing of the jury, establishes a reasonable factual basis for asserting that the conduct of the witness occurred. The conduct may not be proved by extrinsic evidence. So the existence of a complaint is not proof, and this whole debate is simply not relevant to the bill under consideration. As to
Mr. Roca, I just want to pause real quick there. Just, Senator West, does that provide a layer of clarity, or is there another follow-up there? Just we'll close the door of this conversation and then we can move to the process. Senator West, do you want to say something, or? Okay, let's unmute Senator West, please.
Now, I hear Mr. Roca, and I've got a lot of respect for him. He is an advocate. I would love to hear from a state's attorney, who had a chance to hear Mr. Roca as I did, and see whether or not there's any response to that.
Yes, Senator, this colloquy came up at the bill hearing, and after I gave the same description that I gave today, Senator Schellenberg. Sorry about that. Not Senator Schellenberger.
Say it 10 times
Not
fast.
Schellenberger.
Sometimes we think he is because he appears before us so many times.
Indeed. Scott said that he agreed with my description. So I just want to remind you of that, Senator.
Okay, that's great. I will try to get through to Scott over the course of the weekend. And
Likewise.
Okay, great.
Yeah, we both will.
Thanks.
And it just said, we'll see what they pop on. If they do pop on, we'll get his opinion when he gets here. Okay. Sorry, Mr. Roca.
So as to process, Senator Smith, you're correct. The discussion about this bill frequently sounds as if we are discussing a different bill, a bill that mandates disclosure. I would point out that New York recently changed its law last year to indeed mandate disclosure of all police records, with the exception of technical infractions and with the permission to redact specific information. But this bill does not mandate the disclosure of anything. It simply moves IA files from the category of can't be disclosed to the category of can be denied, which conversely also means can be disclosed. But it is the custodian of record who has the discretion to deny. That discretion is broad. It's whether disclosure of the record would not be in the public interest. But the basic idea is that if a custodian of these records is not going to disclose them, they have to have a good reason. And that's a reason that they have to be able to defend in court if the requester challenges it. And there are a number of presumptive reasons that already exist in statute. And those are the 7 reasons that you see on page 3 of the bill. Those are the bases on which a custodian can deny inspection, even by a person in interest. So someone who has a heightened entitlement to the records, but the public is not a person in interest as to those records. And so if these reasons are statutorily presumed to be a legitimate basis to deny the records even to a person in interest, they are also therefore a legitimate basis to deny access to the records to those with a lesser claim of entitlement to them, namely the public. And those 7 reasons address virtually all of the concerns that have been raised about the bill in terms of invasion of privacy, prejudicing an investigation, disclosing confidential sources, etc. And so that's, I think, critically important to understand.
So the another thing I don't normally get, Sheriff Popkin, and then I want to get the FOP's take, and then we'll go to Senator Castley again. But while I have you here as well, I mean, so I also talked at the hearing, I asked about the process, but then also the custodian, like what, so I mean, there is an actual, defined term. So I'm just looking at the general provisions article, and what is section 4101, but official custodian. So I'm just going to read it. A official custodian means an officer or an employee of the state or of a political subdivision who is responsible for keeping a public record, whether or not the officer or the employee has physical custody. So in this case, then, who would the custodian be? The custodian would be.
I mean, we have to speak sort of in legal terms and then factual terms. So in real life, the custodian is the agency. It's the agency that holds the records that someone is requesting. But every agency that holds public records, including every police agency, has to designate a specific human being who's their official custodian of records, meaning the individual person to whom you will direct your MPIA request.
Okay.
And that person is tasked with administering the PIA process with the advice of counsel. In larger agencies, there may be a whole staff of people who are responsible for responding to PIA requests. In my experience of filing PIA requests widely across the state, we almost always end up dealing with someone from the jurisdiction's counsel's office, because they're the ones who, in non-routine matters, advise the designated custodian whether or not the record should be disclosed. Some requests are easy and routine, and the record is obviously disclosable. Some are more difficult and require more thought.
Got it.
But the agency has the records. The agency designates an individual to manage the PIA process, and that individual may or may not have a full staff and is free to consult with the jurisdiction's attorneys where necessary.
I'm trying to unmute. Okay, great. So then that, I mean, to my mind, that just adds more context to the hurdles and the kind of the checks for me. But Sheriff Popkin is next.
Thank you, Chairman Smith. I appreciate just the brief period of time to be able to speak some practical and reality to this. So as you know, right now, should we get a Public Information Act request related to these investigative records, it's an automatic denial. Should this, the way the bill is drafted and the current way in reading this, the process, there's not a law enforcement agency in Maryland that doesn't receive public information requests. Depending on the size of the agency, the more you're getting. And this is something that we get every single day. And especially involving investigative records, right now it's because of court decisions, it's a denial. But if the bill went into effect the way it is drafted, once the case is closed or the investigation is closed, those the denial then becomes next to impossible to deny. And so the reality is those numbers 1 through 7 certainly would come into play should there be a situation prior to the case being the investigation being closed. But once the investigation is closed, most of those things on there, other than the confidential source so we could redact, or endangering their life or physical nature that we could redact, other than that, we will end up getting into litigation, because even a denial, there is avenues to get these records. And so just the immediate denial won't stop this. And that's why we have made that compromise this is such a broad request for all records. The compromise that we have put forward limits some of those to a more restrictive area that I believe the public is entitled to, which is why the chiefs and sheriffs went there. So Mr. Roca does express the law as stated. However, the reality and the practicality of this is we would, if this is just opened up as written, we may be able to initially deny something, but in the long run, we'll never be able to deny it once the investigation is closed, because that's the way the courts have been ruling on many of these things. And once we release this with the secondary dissemination of getting into social media and the potential change that could be involved with somebody actually amending the document, it really goes to an unfair process that would really affect our men and women of our agencies. Thank you, Senator Smith.
Thank you, Sheriff Popp. And also, so I want to do this. I want to go to FOP now. So Mike Davey, I see, is here. If Mike Davey wants to chime in, and then I'm going to come back up to Mr. Roca, and then I'll go to Senator Castle, just open up a new line of inquiry. Senator Castle, you're, all right. Is Mike Davey here?
Yes, sir. I'm here.
Okay,
sir.
there you go.
Yeah, I apologize.
No worries.
Was made aware of this, so I'm trying to scrambling here. I don't have a copy of the Senate bill. I can only give you an overview of what the FOP's concerns are as it pertains to this. Obviously, we're concerned of certain records, disciplinary records that don't affect the public or minor in nature being released to the public that would have no effect of providing any relevant information to the public. Transparency really wouldn't even be, should be a concern over some of that. It gets taken care of by the chiefs themselves. But obviously we are willing and have been willing to sit down and look at any MPI bill to discuss what could be released, what should be released, and what we would be opposed to. Our biggest concern is getting certain information out there about police officers' actions that it could affect them personally, their safety personally, their families personally, because we all know that once these documents are released to the public, they're going to wind up on Facebook, they're going to wind up on all sorts of social media, and we have an absolute concern of that happening.
All right, thank you, Mr. Davey. Let's go, let's see this. Senator Castle, are you there? Where'd you go? There you are.
Mr. Chairman. So just to respond to Mr. Roca's points, I'm going to try to be really clear about this. What the bill does is it takes something that are currently these personnel files and takes them out as the broad protections and moves them into those 7 points. Like it's a George Carlin thing, the seven things here, the 7 categories. But if you look at those 7 categories, the only one of those 7 that even comes remotely close to addressing the concerns that I raised and Frank Boston raised is number 3, which says it constitutes an unwarranted invasion of personal privacy. So if I'm in court as an attorney for the other side, now I'm going to say, Judge, this wasn't, it's an invasion of the cop's life, but it's not unwarranted. This stuff is totally subjective. What's unwarranted? And then it's only the personal privacy. So personal privacy can pretty much be said, look, if you weren't in bed when we found this out naked, it's not personal privacy. So if you were with your neighbor, if you were driving, if you were in subordination, if you were, of all the things I listed, the only thing, and I didn't even get it, maybe the issue with your spouse, because you were in bed at the time, it was personal privacy, but pretty much everything else is fair game. So it doesn't suffice to say, oh, we're taking this out of the general prohibitions, but now you still have these, oh my gosh, these 7 ironclad protections that you can rely upon. It's like the Bill of Rights here for you. 7 iron, those are meaningless. Overwhelmingly, they provide the cop no protection to the information that we've said we don't want to be brought, we didn't want to be brought into public. This stuff is, most of it deals with the criminal side of stuff, with the prosecution, the investigations, which isn't really, that's overwhelmingly not the concern. It's mostly just these intrusions. And to say that judges, so pretty much everything in the file now would have to be disclosed. Everything would have to be disclosed in at least as potentially responsive to the litigation request. We couldn't withhold anything, just say, well, it's it, because it would be such a subjective interpretation that literally every document in the personnel file would have to be brought into the litigation. You'd have to bring it all in. And because then everything would be subject, because number 3 gives you such subjective protections that the lawyers would be in front of the judge on literally every item in that file, arguing whether it was an unwarranted intrusion of a personal privacy. So I find this, if that's what you're relying upon to give the police an iota of comfort that they're not going to have their personal lives spread across the internet, that's a really slender read. That is just, that doesn't do it for me at all. So, I mean, you know, you want to go mountain climbing with dental floss or something. It's just, there's no protections in there. Thank you.
All right, thank you, Senator Castley. Looking around the room, any other commentary? Senator West, and then I'm going to have a question as well. Go ahead, Senator West.
Thank you, Mr. Chair. Okay, so we've heard a lot of defensive statements about why a defense counsel in a criminal case would not be able to get these records. So let me go to Senator Carter, who's the sponsor of the bill. Who would be able to get these records? If defense counsel in a case involving the policeman who was the subject of the complaint cannot get the records, who can get the records under your bill?
The interested parties in terms of the actual victim or the victim's family, as we've discussed in situations like Anton Black, for example, and others whose families were unable to get any information from the police agencies about the investigation or about any potential outcomes of officers. That is a primary group of people that this is designed to help.
Well, then why doesn't your bill explicitly state that the following categories of people are permitted to access the files and view the material, not photocopy them, because photocopying them, they can be handed out to other people, including defense counsel, who could make use of them. But why didn't your bill specifically state that the people who are involved in the complaint have the right to access the files and view the files, if that's what you're interested in?
So that's not the full extent of what I'm interested in.
And what else are you interested in?
Much of this conversation and the defense of the current practice of non-disclosure tends to ignore that we have a real problem in Maryland. And what that real problem is that, and the data bears this out, that records that have remained secret, confined only within police agencies, not disclosable to the public, even the interested parties, the subjects of them, and not disclosable even to boards that are certified to investigate and make disciplinary recommendations, such as civilian review boards, create a blanket of silence around police conduct that has largely contributed to the current distrust between police and the communities and people they serve. But it is also created, it has contributed to a large-scale distrust, because the truth is the agencies that have refused to disclose this information have failed in large part to ensure that those bad officers, the few bad apples that we always hear about, are actually weeded out. Now, the numbers do bear out that within most agencies, the police officers that amass multiple complaints are within a small percentage of all of the police officers in the agencies. I bring that up only to say that for the most part, all of those great officers with a lot of integrity really don't have anything to be concerned about. In addition to that, these are public servants. We are discussing this as if these are not people that are public servants that have an oath, that are obligated to serve and protect the public. And The real problem that we're kind of ignoring in this conversation is that that has gone largely awry in the state of Maryland. And I've been accused of talking about the other places in the country. No, in Maryland, this is one tool in the toolbox. This is one step of many that would help through transparency, help bring us to greater accountability. So that's the goal. And that is why I believe that the potential disclosure, and I want to make this clear because it's been discussed as if this is sort of like the database that Senator Sidnor had proposed, which, that's a different issue. This is not creating a database where officers' records are just going to be accessible to all of the public. This requires an actual request for the information, a person designated by the very agency to make a decision whether or not this is disclosable, and use some discretion as to what out of what is disclosable should be disclosed. Then,
Okay, well,
if that is challenged, then there's a whole other process that one of the people that was here talked about, which is that, the concern that this could result in litigation. Well, it could result in litigation, but at the end of the day, if a record is denied and it's challenged, then at the end of the day, there's still a judge that gets to interpret whether or not it falls under one of the exceptions or which should be disclosed. Thus, I'm saying all of that to say, Senator West, that I believe that there are that the need for the bill is very meritorious and the need for the disclosure of the records is meritorious, but I also believe there are adequate checks and balances within the legislation to protect against some of the big fear.
great. I appreciate the speech. It's basically the presentation you made when you first introduced the bill, but it didn't answer my question. So my question was, you said earlier that you want to make sure that the family of someone who had been injured by a policeman and who had was the same family of the person who filed the complaint should have a right to see the records of how the complaint was handled. And I asked you, who else do you think should have the right to see those records? And if there is somebody else, why isn't it specifically delineated in the bill rather than just leaving it up in the air as to who would have a right to get access to these records?
My answer actually was contained within what you characterize as a speech. I brought up the fact that the secrecy around these records and their lack of the prohibition that they are ever disclosable to a requester or to the public at large, or even to a media source or to a person, in a criminal case or whatever the reason. The fact that they are not disclosable has created the secrecy, which has created the problem, which we are ostensibly working to fix, which is
here's my problem.
the lack of transparency.
Mr. Rook has spent a while trying to convince us that the defense counsel would not be able to get at these records or introduce them at trial, use them at trial if he could get at them. I thought that was the thrust of your testimony. What is there in this bill which says the defense counsel will not be able to see or use these records, but everybody else, the media, the public, et cetera, will be?
Since you
Can I respond to that?
Yeah, I was going to say, since you referenced his comments, I'm going to let him respond, and then we're going to Senator West, I'll let you finish up your line of question, and then Senator Bailey's got next. So sure, go ahead, Mr. Rocco.
So Senator West, I was not attempting to convince you or anyone that defense counsel wouldn't be able to get the records. What I was attempting to explain was that whether defense counsel has the records or not is completely irrelevant to whether they can be introduced in trial. Their ability to be introduced at trial is controlled not by the MPIA, but by Maryland Rule 5-608, which I quoted to you. And that rule makes clear that their admissibility is decided by the judge, and the existence or non-existence of a complaint is irrelevant. What can be admitted in terms of prior bad acts, which is the objection that was raised that this will somehow mess up trials, is there has to be proof of the prior bad act, and it can't even be proved by extrinsic evidence. So a complaint is not proof, and you can't prove it by extrinsic evidence. You have to prove it by witness testimony. And if the witness wants to testify, can probatively testify that the officer engaged in a prior bad act bearing on credibility, then the rule says it's admissible. But none of that has anything to do with the MPIA. So it wasn't that I was saying that the public defender couldn't get it. They could get it, but their getting it has nothing to do with whether it gets admitted in a trial.
Okay.
Can I say
back to
something
where we
about
were
some of the
before,
other?
which is I'd like to talk to Scott Schellenberger. Thanks.
Is he here?
Can I say something about some of the other things that have been said? I wanted to respond to Sheriff Popkin and to Mike Davey and to Senator Casserly, if I could.
Sure. Very briefly, and then I want to get to Senator Bailey, unless Senator West is done. Looks like he is, his chair's empty. Yes, very briefly, Mr. Roca, and then I want to get to Senator Bailey, and then I see Mr. Boatwright has something to say, so go ahead.
Thank you. So Sheriff Popkins said we can never deny after the investigation is closed. That's not true. The standard for denial of investigatory records, as the sheriff well knows, is whether or not disclosure would or would not be in the public interest. The 7 things that we've been referring to are not the exclusive bases for denial. They're simply statutorily enumerated specific, presumptively valid bases for denial. But the general standard that applies to discretionary denials is whether the disclosure is or is not in the public interest. Now, frequently it is in the public interest and it should be disclosed. But to say that we can never deny is simply untrue. And I want to say something about this idea that limiting disclosure only to sustained complaints is a reasonable so-called compromise here. It isn't, because the need for disclosure arises from the fact that 90% of complaints by the members of the public are not sustained, and people want to know whether those decisions are being made properly, fairly, correctly, etc. And disclosure only of sustained complaints is not transparency. It's transparency theater, and it's simply a public relations exercise. If there are problems, they do not exist with respect to sustained complaints. They exist with respect to the unsustained complaints. That's what people are needing to see. And Mike Davey said, we're concerned about the minor complaints. I've pointed the committee several times to the language in the New York law, which again, doesn't simply permit disclosure, but mandates disclosure. But I've noted that the New York law has an exclusion for so-called technical infractions. And I want to read what that exclusion encompasses. A minor rule violation by a person employed by a law enforcement agency as defined in this section, blah, 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 that A, do not involve interactions with members of the public, B, are not of public concern, and C, are not otherwise connected to such persons' investigative, enforcement, training, supervision, or reporting responsibilities, close quote. If the committee wants to exclude technical infractions in the same way that was done in New York, I don't think we or other advocacy groups would have any complaint about it. But the idea that we are only that the solution is to limit disclosure only to a narrow category of sustained complaints is, I think, a profound mistake and completely unrelated to any of the issues that have been raised today or previously.
Okay.
And let me just say one last thing. Senator Casserly was saying that the 7 exceptions are inadequate, that unwarranted invasion of personal privacy is meaningless. Again, I would point to Senator Casserly to the fact that the standard is not simply those 7 things, but whether or not disclosure is in the public interest. That's the statutory standard in the MPIA. And as to whether all of that is meaningless, I would remind the committee that that is the standard that governs the police disclosure of police investigatory records about you, me, and every other person in Maryland. And that standard has governed the release of those records about all of us for decades. And so if it's so insufficient and meaningless, why has it, without any apparent problem, been the standard that should apply to the equally sensitive, if not more sensitive, records of police investigations into you, me, and everyone else?
Fair point. Thank you very much. Senator Bailey, you're next. And then I want to make sure that Mr. Boatwright and then Morris, if you have your responses that were responsive to the dialogue that we've been having right now. So Senator Bailey, you're up. Question, go for it.
So I'm going to try to get this in the form of a question, but I'm going to make a couple statements sort of to start with here. And what I was going to say is, from being a police officer for 30 years and going through investigations where people actually look at your personnel file, this is routinely done if you are a policeman that is making criminal arrests. And I know a bunch of members that are here are familiar with the criminal proceedings, but when we talk about criminal proceedings in Maryland, and because so many of us are involved in also federal cases, Brady and Giglio precedents require police officers to be especially careful to avoid any actions or statements that compromises their credibility because it compromises their job. And when you make an arrest, the prosecution is legally required to disclose misconduct of the officers that might be witnesses and compromising information to the defense. That has to be turned over in discovery. That is very important that we remember that. And I know from being a police officer that when I would do a case that involved an arrest and before prosecution, my colonel would sign and he would send it over that it was reviewed, and anything questionable in my file would have been turned over to the defense. So the issue is that we are talking about when this blanket statement is, well, these officers are running around with these bad personnel files that are going to contain all this. If we do Information Act or something of that, a FOIA request, I'm going to tell you, if you tell a lie and you are caught in it, you lose your job. It is just not going to be the gold at the end of the rainbow by having this. And the other thing that I would say is, from representing officers and talking with officers in different departments, there are circumstances where departments are required federally to not have these records, right? There are times in departments, because of things such as consent decrees that require after a certain number of years, which is not long, that the personnel files, the internal files on that officer are simply terminated. They are destroyed. So those records don't exist. And that is done based on, court records. So I would, and court decisions. So I would say that there is some definite areas of caution as we move forward with this. I appreciate the opportunity to discuss this, but I think Mike Davies would probably be a good person to jump in on this. Thank you.
All right, thank you very much, Senator Bailey. And for Senator West, we do have Schellenberger. Mr. Schellenberger will be on in 5 minutes or so. You're able to shed some light on that perspective. So let's go. I saw Mr. Boatwright is next, if it's responsive to the dialogue. And then I want to go to Chief Morris. And then let's see there.
Mr. Chair, Mr. Chair, good afternoon, members of the committee. My name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order of Police. I just wanted to clear up a little bit of language of part of the discussion earlier when we were discussing sustained complaints. That is when the investigator sustains it, the internal affairs investigator. The term we were all looking for earlier was a guilty finding, and that comes in the form of a trial board. And so the guilty versus sustained, like was said earlier, is unlike what most people are familiar with. Just the mere fact of you being having a sustained case, that means that the investigator found sufficient charges or sufficient evidence to charge you with the complaint. Secondly, with this bill, I've heard a lot of discussion talked about our police officers, the 21,000 plus police officers that we represent in the Maryland State Police, Maryland State FOP. We respond to over 4 million calls per year. And our men and women go out and work hard every day. And I think it shouldn't be lost that our men and women feel as though, some of these pieces of legislation to include this is an obvious attack on our profession. However, we understand there should be some transparency, and we would like to have, to be a part of those discussions as they go on. Another thing I wanted to add, Sheriff Popp made a great comment earlier when he talked about the safety of our police officers. Once this information is shared by one person to another, once you have the secondary sharing of these documents, there is no way to determine whether or not these documents were altered or anything like that. So I think these are important concerns that we have. And I just think that, the men and women are watching this legislation and others, and we just ask that you continue to support our police, and we would like to be a part of any discussion moving forward. Thank you so much, sir, for the opportunity to speak.
Of course, definitely want to make sure everyone's voice is incorporated. All right, we've got, I thought we had Chief Morris. Are you still want to speak? I thought I saw your hand up.
Yeah, Mr. Chairman, thank you. I'm going to defer to Chief Hamill.
All right, Chief, other Chief Hamill.
Thank you, sir. Just to make sure, can you hear me?
You can, yes.
Okay, thank you. I'll be quick, and thank you to Chief Morris for deferring. We would echo what Mr. Boatwright has mentioned about transparency and when to be part of the solution here. I do have some concerns about some testimony that's been offered here today regarding minor infractions wouldn't be part of or subject to discussion. And I think that that's actually less than transparent. I think, look, the esteemed counsel that are speaking here today, I'm nowhere near the lawyer Mr. Roca is and some of the others that just spoke. I probably couldn't carry Mr. Roca's briefcase into court for him. But I'm enough of a lawyer to know that if I have a client in a case and there's an officer that has continual minor infractions, not wearing a name tag or speeding or some other minor violations we referred to, I'm enough of a lawyer that I would bring that up in front of the court once I found out about that to demonstrate that if that officer can't follow those simple rules, how can we trust the officer to follow the rules in the case in hand? And I think it has, unless we really corral this has the unintended consequences of turning some of these trials into theaters of the absurd that will just go completely off track in these areas. I think I know what the focus here is, and I agree with the focus. We need that 10%, as some of the senators have mentioned, that 10% of officers of concern to be placed in check on this. And that's probably bad terminology, but I think we all know what I'm saying there, that we need to address those concerns and address them properly. The idea of public servant transparency should be embraced by every one of us. Frankly, I do question a bit that this public servants transparency is being directed only at law enforcement, and why not all public servants? Because if we are working for the government, aren't we indeed all public servants? But so that does cause me a bit of concern. Also, there was something mentioned earlier that mere records of complaints aren't proof. They wouldn't be admissible. And I thought somehow they could possibly get in under this, or maybe it was other legislation. So I apologize for that, under public records exceptions or other exceptions. And maybe that's not this current legislation. But I just felt the need to really be cautionary here in regards to how broad this could be. And I really think some of the alternatives that have been offered should be given due consideration by this committee. And I appreciate the time you've given me to speak here. Thank you, Chairman.
I appreciate it. Thank you. Thank you, Chief Hamill. All right. Looking around the room. Back to Senator Carter. Did you have something or no? You're good?
It may not be necessary. I don't want to drag this out any longer than it need be, but I'd like to get down to the nuts and bolts of rather than, discuss generalized opposition. If someone had specific language that they were proposing that we could consider, such as related to minor infractions or technical infractions, that they be excluded, that's something we could consider. I think that, this is about specific language, but not just kind of the general discussion that we're having. I also would just respond briefly to Mr. Boatwright that we're talking about a profession of public trust, and the fact that I kind of take offense at your characterization that any of this is an attack on your profession. This is actually, as I've stated many, many times, designed to improve the perception of the integrity of your profession and the actual integrity of your profession. As we know, about 85 to 90% of all officers within every agency are not going to be in any way even impacted in a negative way potentially by this legislation. But this is designed to help you get at those bad ones by the public disclosure. So I just want to make that clear because I do kind of resent the characterization. No one here is trying to attack, well, except for some of us maybe, but no one is here is trying to attack the profession of policing. We're simply here being responsible to our constituencies to try to make it better.
That's good. All right, Mr. Boatwright, respond.
And thank you, Senator Carter. With us both being from Baltimore and having access to each other readily, I appreciate your comments, and I invite that discussion to where we're not waiting until the session to try to fix a problem, and that we could be a part of the discussion on the onset. Just like, this piece of legislation has dropped, we would have liked to have had an opportunity to be at the table drafting this legislation where we could have given you input. And my comment was simply based on the fact that we have, hello, State's Attorney. So we have these statements of the mistrust or the public trust, and we get that there are some issues within our profession. However, the fact that Marylanders call us 4 million times a year to come to their aid tells us that there are more people that believe in the police that do not. So we would invite the conversation to make our profession better, but if we're going to be helped, let us be a part of the solution to help ourselves as well.
Thank you. Well, actually, this legislation was first proposed in September and for the past 2 legislative sessions, so we didn't wait until January. In addition to that, Commissioner Harrison was actually a part of the discussions and expressed a great deal of support for many of the pieces of legislation. I can't specifically say where he weighed in on this one, but he was generally pretty supportive. I'd also just point out that the consent decree actually is indicative of the fact that it's not me or just a few people saying that there's a problem that needs to be fixed, but it's the federal government that said it.
Excellent, thank you. All right, so I want to go over to Senator Casserly, and then Senator West, if you want to repackage your question for Mr. Schellenberger, he is here now to answer. Senator Casserly, go ahead.
Yeah, so I want to be fair to Senator Carter in on this because, I don't want suggestions that she's, sort of motivated to go after folks, because I understand the end game here is more accountability, and I appreciate that we're looking at this in a broad array. I mean, we're looking at it from what records come out, who does the investigations, who does the hearings, who makes the final decisions. You know, we're looking at everything. And so I appreciate that she brings up this piece of it, right? This is an important piece to look at because it does talk about what are the records. And I also respect that the public information component of the general provisions under the code are pretty complicated. I mean, we got 4103, it's a general right to information that everybody has access to. 4103A says, in general, everybody has access to all public records. That's your general theory. And there's an exception for personnel records. So whatever we can put in personnel records is totally, it doesn't come in at all. But then we move in, if we say that these investigatory records are not part of personnel records, and they come under 4351 investigative records. And then looking under there, that you can still deny custodian of records of investigations conducted by a police department or a sheriff. But what we don't know is how broad, how good of a net is that? Can we put everything we want in a net that says that's like that? Because these things were previously under the personnel records net, and now we're putting them in this new net and saying, is this going to give us the protections we want? And that's the concerns that I think a lot of us have. It's not that we shouldn't look at these things and say, hey, let's look at some of these complaints. It's what are the protections that are giving them? Once we pull out of personnel records and put them in this new net, are those protections sufficient? And I mean, that's a difficult analysis to do, in my view, and it really comes under 4351 of the general provisions article. And I, for one, would like to get better information on, are those considered, what's in that personnel file that would be considered under 4351A subparagraph 1, records of investigations conducted by the county or police department or sheriff, which inspection can be denied, except that for persons of interest. And then how much protection do we have under that language for persons in interest? And it gets pretty specific. I mean, it would be helpful if we could take specific records and say, let's do an analysis on, what are the specific records that people are concerned about here, not disclosing them, and run each one of those records through this analysis and see whether that analysis is sufficient to protect the things that we want. Because maybe it's a matter of fixing up a little bit 4351 to provide the protection stuff that we pulled out of personnel files in. I mean, we don't want to use the personnel file exception as a catch-all to just throw everything in that folder. If it's a personnel file, they're not discoverable. So if we throw everything in the personnel file, then is that really fair to say, well, everything's a personnel file, so you don't have to look any further? Or should we go a little bit further than that and actually look beyond that? And I think that's where Senator Carter's coming from. So, I don't mind going through that exercise. I think it's going to take, I think we need to sit down and actually look at some records with some folks who are really good on public information requests, though. Thank you.
Well, hello all. So I didn't know anything about this till about 20 minutes ago. I assume we're talking about SB 178 and
Yes,
the interaction for all these bills. So I believe the question was, would a defense lawyer really go after these things if they were available? And my response is yes. I'm not only concerned that they would go after them, but I am actually concerned that someone from behind the scenes could manipulate the situation. And here's what I would say. And of course, I do not believe any defense counsel will be involved in this, but say a defendant is on trial. There is one witness who's a police officer who's extremely important and whose credibility, if it can be damaged, might result in a not guilty. What would stop that defendant from asking a friend of a friend to make some allegations against the person? The allegations go into the file. 178, as it's currently drafted, would would make that file available not only to defense counsel through a PIA request, but also would be available to the public, which then could ask for it and forward it to the press. And the next thing you know, you're getting cross-examined about a mere allegation, and a jury might have already read about a mere allegation. So there's a place where I drew the line at sustained filings. Now, I've been thinking about this since I put that out there, and I'm coming up now with an interesting idea. And Chairman Smith, I hope you're interested in this, because I hadn't mentioned it when we had talked before. So what I think Senator Carter is trying to do is make sure that the defense attorney has information about possible untruths being told by an officer. And if we have to wait till a sustained finding, that's going to be a big delay. And if there is underlying distrust of sustained findings, then just turning those over might not do it. What if the bill said that you all ordered the Rules Committee to draft a rule that would make this kind of information mandatory discoverable? And then we would have to write a rule that says the state must turn this over in discovery. And we could even craft the rule that would require defense counsel to sign a non-disclosure agreement to the public, and then have a hearing in the courtroom and let me and the defense lawyer argue in front of a judge in a specific case, will this be admissible? And Senator Carter, I see a little smile, because I think that would get to the thrust of the matter, and that is make sure the defense attorney has all the ammunition they can. And I can tell you that if you talk to John McCarthy and some of the other state's attorneys, we all get weekly updates on allegations that go directly through truthfulness. And it seems to me that if you all passed a law saying that we need to have a rule that does this, I think we could get to a good place where it wouldn't have to be in the newspaper on Channel 2, but it would go to the right person like Senator Carter, who has the right to try and cross-examine. I think that's what we really want to do. And all the people on the line, my fellow chiefs and sheriffs, I know I didn't discuss this with you, but I think there's a middle ground we can get to.
Senator Carter, I will give you the first chop at the response.
I hope I didn't step out of line.
No, a quick first chop. Just briefly, that process sounds pretty attenuated, pretty complicated, and much of the opposition I've heard earlier was the concern that these situations could result in additional litigation, and so that doesn't seem like that cuts down on that. But I also want to make it clear, Mr. Schellenberger, that the bill, as I expressed earlier, and I think others have expressed, it's about much more than just the ability of a defense attorney to get the discovery in a criminal case, or it's broader than that. And I would say that, the Public Information Act is for disclosure to the public in certain circumstances, not just merely, it's beyond discovery in a criminal case. So, I mean, it gives you comfort in a criminal case.
If that PIA piece was limited to sustained findings, let me show you how hard this would be from a process point of view concerning discovery. I have a case involving Officer so-and-so. Can you send me his IA file so I can look at it, because I may have to provide it in discovery and I need it tomorrow. That's the process. And then I get the file, I look at it, and I say, oh crap, he's accused of lying, and we are 6 months away from a trial board. I need to call his lawyer, Public Defender Carter. Jill, I got something for you. You need to sign this non-disclosure. And then Senator Carter reads it, files a motion with the court, says we need to have a hearing. It can be during pretrial hearings that happen all the time. It's one more aspect. You put the file in front of the judge and the judge says, admissible, not admissible. Now, when you get to trial, that's where the public learns, because it's a public trial. The judge has ruled it's admissible, and now the mere allegation is going to come into the public record. So let's separate it out. Sustained findings are subject to PIA. Mere allegations, but dealing with truthfulness, get turned over in discovery and quickly litigated in front of a judge. I don't think that's a difficult process. You know, we feed each other information all the time. I actually think this is a workable solution. I hope my friends with the chief and sheriffs don't call me and start yelling at me.
I'm not sure that that takes us where we need to go. I mean, in my recollection, when the last time this has come up, the state's attorney has alerted me or alerted defense counsel that there's an issue that we're allowed to review. And then we review it, and then we then get, as you just described, a chance to argue in front of the judge whether or not it should be admissible. So I'm not understanding how that is different than current law. And I'd also point out that I think that some of the concern about the unsustained complaints is not necessary, because many unsustained complaints are expungible pretty quickly. And so if it's anything that's even remotely old, it's generally not a part of the file anymore anyway. Like unsustained complaints disappear pretty quickly.
Well, respectfully, I'm worried about that window, which often is up to a year from the time the complaint is made until the finding of unsustained. And it's that window that I'm concerned about. And the difference is coming out in a courtroom, maybe that hearing dealing with admissibility is closed. But once the judge rules it's admissible, then at the trial, it's open and it becomes public. But and that's where we keep coming back to, you know, there needs to be one more step from just a mere allegation. And that's the same method we have when we charge people. You know, so-and-so assaulted me. You go to the commissioner. Well, a mere allegation doesn't get past it until I sign under oath and a judicial officer has determined it's admissible. I am concerned with it appearing on the 6 o'clock news when it's just a mere allegation. And I think my solution of separating sustained versus unsustained, one is public and one is discoverable, I think it solves a lot of the problems. And honestly, I've just been ruminating over this since I've heard this conversation. You know, I would love it to be limited to sustained, but I'm a realist. You all know I am. And if the solution is to fix the courtroom problem, not make it public to everybody.
So I just feel that, and you can, you know, give me your opinion, as I'm sure you will. You know, my interpretation though is that this bill specifically excludes the immediate investigation that is open, that has not yet been adjudicated sustained or unsustained. So I don't think that I think that's covered because this bill does not allow for that disclosure. It's only about the ones that have already, they're older, because it says it doesn't allow.
Well, it's also not limited to truthfulness. And, you know, that's what goes directly to the heart of what happens in a courtroom. So obviously, if the allegation in the courtroom is the officer's use of force, then obviously prior uses of force would be relevant. But I think it has to be driven by the relevance of the case. Truthfulness is always relevant, from a speeding ticket all the way up to a murder case. But sometimes use of force may not be relevant if that's not involved in the case. And that's why I think you need that arbiter which we all look at as judges to decide whether it's relevant or not. And I don't think it should be public until it's been decided that it's relevant or a sustained finding.
I do think that we need to go beyond just the issue of veracity or truthfulness. Much of the impetus for the legislation really is around excessive force. And so, for example, I remember from when I was working with the Civilian Review Board that oftentimes officers would have a history of harassment unsustained, discourtesy unsustained, excessive force downgraded to something conduct unbecoming or a lower chart, a lower allegation. And then, you know, ultimately there's a big deal case, and all of those prior allegations that were unsustained, unfounded, or ignored that could have been warning signs before the officer got to the point of maybe operating as if he or she were GTTF, or, you know, operating in an extrajudicial killing. They could have been used as warning signs before that officer got there, but largely they just weren't given any credence or any real attention by the agency.
And I don't want to go to another bill, but that's why the early warning system that you all are talking about, I think is a good thing. I mean, everybody on this Zoom right now understands that the culture needs to change. We all get that. And so, you know, what you just mentioned about the 3 prior incidents, one of which was downgraded, that needs to be plugged into that early warning system. So every one of these chiefs and sheriffs know that when that bell goes off, because we're on number 3 within a 6-month time period, I better do something or we're going to be answerable to the public. So I agree, all these things tie in, but you have described exactly what that early warning system means.
But that's also, the early warning systems are also shrouded in secrecy. You know, they're still within the complete, you know, cloak of secrecy within the agency. My just take. So I'm gonna let anyone else that wants to respond.
I do want to, Senator Cassidy's going to chime in here. I want to make sure you're going to.
Yes, I mean, I think we made a lot of progress here, because if I listen to Senator Carter and Mr. Schellenberger, I'm looking at the chiefs and sheriffs, what they propose, and looking at their specific language. If you take that and include that, it says, look, under these alleged, you get it. On number 2, under these kind of alleged, you get it. Now, as these sustained, we limit it. And what Senator Carter would be looking for is another, as he says, and as to these sustained investigations, you get it for all these other stuff. And what she's looking for is a number 4 that says, as to the unsustained investigation findings regarding the things that the sheriffs and chiefs allow, what's the next process? And Mr. Schellenberger's suggested, well, here's that process. I don't know if his process is exactly what we want to do, but it seems to me that at this point, all we're really discussing is the paragraph number 4 of the chiefs and sheriffs amendment. How does that read? And what would that process look like? Would that be, as Mr. Schellenberger suggests, he gets a protective or a confidentiality agreement? Or does this go to only defense attorneys? Does this go to some other body? Does it go to Senator Carter referred to the other body? I apologize, something with police misconduct or something. So, but really, if we take the chiefs and sheriffs 1 through 3, that concedes a lot of cases right there. Then we're just talking about a paragraph number 4, unsustained. We come up with a process that's being debated now between Mr. Schellenberger and Senator Carter. And I think it's a matter of just what that process is. And I think it moves us very far ahead.
And what better place to put that process than the one that already exists? And that is in the judicial system. You have a fair arbiter who can decide this comes in, therefore it's now going to be public because it's going to come out in the trial. Or this doesn't come in and Senator Carter doesn't like the ruling, I win the case, guess what goes up on appeal? That's the process. That number 4, and I apologize, I have not seen the chief's amendments, but I think focusing in on that, what better place to put a process than one that already exists?
I want to do, just to have a balanced conversation, I want to have Mr. Roca respond, and then we are going to go back to inquiries from the senators.
Thank you, Mr. Chairman. So first of all, as to the need for a quote unquote, this conversation is sort of utterly divorced from the way things work and the actual rules. So as to whether we need a process for things to be admitted in court, we already have a process. It's laid out in Maryland Rule 5-608B, and it says that things you can impeach. I mean, I quoted the rule to the committee. You can only impeach a witness if the judge decides that the prior bad acts are probative of a character trait of untruthfulness, and that the judge has to decide before the questioner can ask the person about it whether it's probative. So, and there's no extrinsic evidence. So there's no complaints introduced in court. It doesn't happen. All that can happen is the questioner can ask the witness, and the questioner can't ask the witness anything, not one thing, unless and until the judge approves. And what's the standard for the judge approving? Whether it's probative. And a mere allegation is not probative of anything. So this whole conversation is just utterly divorced from reality. And now we're talking about the idea that the only context in which this is relevant is in impeaching a witness. It isn't. The point I was making is the whole discussion of impeaching witnesses is utterly irrelevant to the discussion of the MPIA. And now suddenly we're talking as if the only context of disclosure is how we're going to impeach a witness. There's already a process for impeaching witnesses. And the discussion of the MPIA has nothing to do with it. And as to Scott's concern that someone can manipulate that process by filing a complaint, I'm sorry, Scott, but that again is utterly divorced from the way things work in court, as I know you well know.
But it's not the courtroom I'm worried about, it's Channel 2 News. And
okay, well then let's talk about Channel 2 News, because if we're talking about Channel 2 News, Scott, we don't need to be talking about the MPIA. If I want to accuse an officer on Channel 2 News, I can do that whether I file the complaint or not.
There's a big difference between standing on a corner saying this happened to me and saying, oh, they've opened a file about my allegations. It's in the police department. Huge difference in credibility. Huge.
But I can say that again right now. I can say I filed a complaint and they've opened the file. The idea, I mean, here's the other thing. Scott, let me finish my sentence. All these hypotheticals about all these terrible things that will occur, neither Scott, nor the chiefs and sheriffs, nor the FOP, nor anyone else can point to a single instance of any of this occurring in any of the multiple jurisdictions where these records are not shielded from disclosure. It's just a fantasy. We don't have to talk about hypotheticals about what might occur, because we know what does occur in the jurisdictions where these records are not only allowed to be disclosed, but for example, in New York and other states where they have to be disclosed. And they can't point to even a single example. So why are we talking about these ridiculous hypotheticals that have no grounding in the way the law actually operates? And let's have a conversation based on reality.
All right, I'm going to give Scott, go ahead, Mr. Schellenberg, you go ahead and respond, and then I'm going to kick it over to Chief Morris. And none of us look as cool as Senator Sidnor, but my blood pressure's up right now. I don't know about you guys, but all right, Mr. Schellenberg, go ahead, and then we're going to kick it over to Chief Morris.
So number one, I've never asked any of these other states what's happened, and I don't even know how long these laws have been in place. I'm not the most inventive person in the world to come up with hypotheticals. You know, when people's lives are on the line, meaning they may go to jail for a long period of time, they can get very creative and very, very inventive. And I'm not trying to make anything out there. What I'm saying is nowhere else that I know of can a mere allegation cause somebody to open a file and cause somebody to get a PIA request. And the next thing you know, it's all over the news. I mean, I would remind this legislature that if somebody makes an allegation against one of you, it goes a pretty far way before it becomes public in any way. And I just think there have to be some protections. And it sounds like the chiefs have given a lot. And I'm just trying to find that one little part that is a little different. That's what I'm trying to do.
Thank you, Mr. Schellenberger. All right, we're going to go to Morris, Chief Morris.
Yes, sir. Mr. Chairman, I'll be brief and thank you, because I will say that, Scott, the chiefs and the sheriffs have been texting each other back and forth on this, as you might imagine, and we appreciate what you've suggested and find true value in that. We'd also like to think that level heads and cooler heads will ultimately prevail in these discussions. I will state that it is offensive to suggest that the chiefs and sheriffs are offering some sort of a public relations stunt, as has been suggested. We've been at these hearings and engaged in these conversations with a high degree of genuine interest and accommodation and concessions as we look at this. We're just trying to find a fair and balanced approach to this. We set high standards, as we should, but to set impossible standards sets our officers up for failure and risks damage, irreparable damage to their reputations and harm to their families and to our agencies and our communities. So I just hope that cooler heads prevail, as I know they will. And Mr. Chairman, I shared with you and members of your committee a very personal situation in which I was the subject of an utterly false complaint filed against me strictly because an individual under my command didn't like my command decision. So those are the realities of the world in which we live, and to suggest otherwise is disingenuous. Thank you.
Thank you, Chief, and appreciate your work with us through the last couple months and years, frankly. All right, so look, I'm gonna no further questions from the senators, so I'm gonna give everyone 8 minutes back of their lives for this. I thought this is helpful for me at least, and I think this is kind of a prelude to what our voting sessions look like. So to get a lot of this kind of flushed out now, and I'm sure that's giving some folks some ideas for a couple of amendments and other suggestions for arguments later on down the road. So I think this has been fruitful. Really appreciate everyone's participation. Senator Bailey, if you have something to say, I'll go ahead, unmute you.
Thank you very much. And obviously, this is very near and dear to people's hearts when we're talking about their life and their future. And the thing that I wanted to say is, when we're talking about this, I appreciate everybody's candor on this call. But an officer's career lives or dies with his or her reputation and credibility. Remember, in today's day and age, there is something that still exists, and we are all innocent until proven guilty. An unsubstantiated, unfounded complaint should not be able to be such a harassment or a life changer that it has the ability to take their career. Not, law enforcement is not just a job, it's a career, but take it away from them and their families. Because listen, as these chiefs will tell you, and I had partners and things, there are energetic officers that really are trying to make a difference. That's why they entered the field of law enforcement. They feel they can make a difference, and they are out there making a difference. And all of a sudden a community says, you know what, if we call in this many times, we can get rid of that person. That's not fair to the system. The system needs to be fair to all of us. Thank you.
Thank you, Senator Bailey. And that's why I appreciate having you on board this year, especially, and same thing with Senator Jackson. So looking forward to the dialogue as we move forward. Look, as we get closer to voting a package out, the only thing I can tell you is that we're going to give our level best effort. Some folks are going to be disappointed with what we do, and some folks are going to be a little bit more pleased with the final product. That's just the nature of things. So I just appreciate everyone, lending their time and expertise, and I hope you all have a great weekend. I'll see you all on Monday. Thank you all so much. This has been really helpful for me. Thank you. Have a good weekend.